Welcome back. Now, taking the workshop further, now we'll have a second session. This session pertains to legal parameters for preliminary assessment of child in conflict with law under Section 15, decision of bail, and how the application under Section 12 of JJ Act 2015 is to be dealt. So in this session, we shall be dealing with criteria to be adopted in preliminary assessment of a juvenile who commits heinous offense and is between the age group of 16 to 18 years, and the method of determination of juvenility, effect of delay in preliminary assessment, whether the said exercise can be done at the fag end of the inquiry, and the insight of criteria to be considered at the time of deciding the bail application. For that, I would like to invite Shri Pramod Goyal, Learned District and Sessions Judge, Sonepat. Briefly about the sir. Sir practiced as advocate for 19 years. He also remained as Deputy Advocate General for Union of India. Sir also taught for 4 years in Punjab University. A well-known face in judiciary, Sir joined Haryana Superior Judicial Services in the year 2008, having been posted at Faridabad as his first place of posting. Having held many postings and assignments during his illustrious career, Sir became District and Sessions Judge in the year 2015. With his last assignment as Member Secretary, Haryana State Legal Services Authority, Sir is now currently posted as District and Sessions Judge, Sonepat. So I may please invite Pramod Goyal, sir, to please take up this session. Sir.
Good morning, friends. The topic which has been given to me to interact with you, they are all practical topics. The guidelines are already there in the Bail Act, in Juvenile Justice Act, everything is detailed. It is the applicability which is in question, how these provisions are to be applied in a given case. This session has to be an interactive session. It can't be one way. It has to be the participation of each one of you is very important, because this is one topic. No one can come to a conclusion that he is master of it. We keep on learning every time with each and every new case. New facts and circumstances, new cases, they all enrich our experiences and tell us how to deal and how to make a preliminary assessment, or how to, and what circumstances bail is to be granted and bail is to be denied. The principles are not in dispute. The main problem, how these principles are to be applied. So to start with, I'll put 4 different situations. Now, we'll have the answers of those 4 situations subsequently after having some discussion on this topic. A girl, 14 years old, was married. She remained in an abusive marriage for 3 years. Her husband used to beat her on regular basis. At the age of 17, that is 3 years in the marriage, on one day, the day of occurrence, her husband gave beatings to her. She gave a single axe blow to her husband, resulting in his death. Now the question before the court was whether she should be tried as an adult because she is more than 16 years. She has committed a heinous offense. Let us take second situation. In fact, these all situations are live situations. They are actually the actual case facts which I am sharing with you. The second situation pertains to Gurgaon. In a school, a boy was killed, found injured in fact, in a school bathroom. He was taken to hospital, he died. Initially, investigation was made by police. As per police investigation, the chowkidar of the school was arrested. He made confession. However, there were many things which showed that he may be innocent. There was a lot of hue and cry. The matter was transferred to CBSE, and CBSE took over the case and charged a juvenile, a student of same school who was more than 16 years, and he was charged. Now the question was whether preliminary assessment of said boy, whose test was taken by a psychologist, and the test after the test reports were not shared, or rather shared just 30 minutes prior to arguments with the advocate or the family and the juvenile, and he was declared to be an adult, to be prosecuted, to be dealt with by children court. The third situation is about a boy who invited a 7-year girl to his house, committed rape, and killed her. A assessment was done about his background. It was found that he was neither remorseful, he knew what he was doing, he explained the act in a very cold-blooded manner, and the question would be whether he should be treated as an adult or he should be still treated as a juvenile, and his case is decided by the board. The fourth situation, which Madam Sonia has also referred, that was regarding a Bombay case, where accidentally a neighbor was killed by a juvenile, and subsequently he along with his friend tried to conceal the dead body and made ransom calls, and when he was interviewed, it was found that he was remorseful, he understood, but he maintained that the act was an accidental act. Now these are the four situations. Now you have to decide. It is up to you. Now I have left to you to decide in what situation the juvenile should be treated as an adult and be tried by children court, or he or she should be treated as a person who is not adult and treated by the board. To understand these situations, it is very important to understand the concept and the philosophy and the purpose of the act. Unless we understand the purpose of the act, we will not be able to apply the provisions of section 12 or section 15 when we are supposed to make decisions as regards to preliminary assessment or for granting the bail. So, though Madam Sonia has in detail discussed different definitions, different provisions of Juvenile Justice Act, however, I will still like to go through the bare provisions again very briefly. I will not take much time. And why it is so important, why I'm going back and repeating the things which already you are aware of and which have already been discussed in the previous session. The reason is that India is one of the countries where child population below 18 years is 450 million, highest in world. And section 15 came in being because of public opinion. You see, the initial act of 2000 had no concept of preliminary assessment. Children, all children below 18 were taken as it is. But a legal fiction has been created by 2015 Act. Why was it created? What was the necessity? The reason was Nirbhaya's case. Everybody knows that in Delhi, a young girl was brutally raped and then given injuries resulting into her death. A juvenile was also involved in that occurrence. There were a lot of hue and cry. Public opinion was the public opinion was that such like children should not be given benefit of Juvenile Justice Act. Therefore, it was not possible to simply take the safeguards of Juvenile Justice Act, because Juvenile Justice Act was enacted under the mandate of United Nations. India is signatory to United Nations Convention, and as per those conventions, juveniles are protected, safeguarded, and India has agreed to implement those safeguards. The 2000 Act was enacted in view of those mandatory, you can say, the international obligations which India has undertaken. So a committee was formed. It was headed by former Chief Justice of India, Justice J.S. Verma, and a unique concept of preliminary assessment was introduced. What is preliminary assessment? It is a sort of inquiry to find out that a person, a juvenile who is in conflict with law, should be tried as an adult, or he or she should be given benefit of juvenility. Now, before this preliminary assessment, before this is made, we must understand the purpose of the act, the spirit, and you can say the why this act was enacted. Whether it is a normal criminal process to punish a culprit, the answer is no. It is not a, if you see the act, this act is not to punish somebody. It is an act to safeguard children. It is beneficial act. It is not, it is not punitive act. IPC, CRPC is a procedure only. IPC is a punitive act. But Juvenile Justice Act is not a punitive act. It's a reformatory and a act which is beneficial to the children. So, before we proceed further, let us go through the provisions which would be helpful to us to arrive at the decisions on the illustrations I have given to you. Section 2(9) talks about best interest of child. What is best interest of child? To ensure fulfillment of his basic rights, need, identity, social well-being, and physical, emotional, and intellectual development. Why I am reading this? The reason is, whenever you make preliminary assessment, being a member of board, it is very important that these particular definitions are kept in mind. You cannot arrive at a decision with a punitive mind. You have to have a mind favorable to child. Unless that mindset is changed, you will not be able to come to the correct conclusion and enforce the mandate of Juvenile Justice Act. Then child-friendly. The term child-friendly is defined under section 215. It means any behavior, conduct, practice, process, attitude, environment, or treatment that is humane, considerate, and in the best interest of child. Now, Honorable Mr. Justice Masi was also talking that we should be humane. He was referring only to the act, that unless we act as human beings, we are humane, the purpose of this act cannot be implemented. This act cannot be implemented. We cannot, in fact, interpret the provisions of this act without being humane, without understanding best interests of child and ensuring child-friendly environment in the court as well as in police station, as well as in all, with all stakeholders. Now, there are three more important definitions. They are of petty offenses, serious offenses, heinous offenses. I'm not going to it. They have been divided as per the sentence for which a particular offense has been sentence given for a particular offense. The parameter is 3 years, 3 to 7 years, and 7 years. Earlier, in 2015 Act, there was an ambiguity which was taken in notice by Honorable Supreme Court in Shilpa Mittal case, wherein Honorable Supreme Court concluded that the offences wherein minimum sentence is not as 7 years, they cannot be taken as heinous offences, they have to be taken as serious offences. Now, as Ms. Sonia has informed us that in 2021 amendment, the things have changed and such offences have to be treated as serious offences. Now, apart from these important definitions, there is another important aspect. How much is the sentencing part? What can be done if child is found to be in conflict with law? Section 18 provides the answer. Section 18 says that maximum 3 years in special home if a juvenile is found in conflict with law. And in case the child is tried by children court and as an adult, then he can be given punishment of the offense prescribed, but he cannot be sentenced to death or life imprisonment wherein he has no chance of coming out. So these are two riders, these are two punishment which are prescribed. Then section 10 lays down the procedure, how when the child is apprehended, to whom it will be placed, in whose custody it will be placed. I'm not going into all this. Thereafter, the child has to be produced before the board within 24 hours. Then comes the stage of bail. Now, what are the provisions of bail? They are contained in section 12. The words are be released on bail with or without surety or placed under the supervision of probation officer or under the care of any fit person. The words are very clear. Section 12 says bail is a right. In general law also, bail is right, jail is exception. But in case of juvenile, it has gone a step further. Herein, in all cases, mandatorily, the bail has to be granted. Bail cannot be denied except for 3 reasons which have been given in the section 12 itself. Section 12 says that a juvenile will not be released if there appears reasonable ground for believing that the release is likely to bring that person in association with any known criminal or expose the said person to moral, physical or psychological danger, or the person's release would defeat the end of justice. Now, most of the cases, when I act as an appellate court and go through the appeals filed by juveniles against the orders passed by board, most of the bail applications in heinous bail pleas in heinous cases are declined merely by stating that there appears to be a reasonable ground for believing that the release is likely to bring the juvenile into the association of some known criminal, or that he'll be exposed to moral, physical, or psychological danger. Now, this is the basic ground. Generally, in 90% of cases, the boards are declining the bail application on these grounds. I am afraid that this system, this approach is not acceptable. We cannot deny the bail merely by reproducing the mandate of Section 12. There has to be some material to conclude. These are the conclusions. These conclusions must be based on some reasoning, and reasoning has to be based on some material. Unless there is a material, by simply writing that the juvenile will come into the company of somebody who is not proper for his development, or it will expose him to moral, physical, or psychological dangers, is not sufficient. We need to conclude the material which is placed before us, before the board, to conclude that actually child is in danger and bail is going to run against his interest. Against his interest is the basic thing which can only be reason for denying the bail under these two clauses. So my request to all of you is that when you apply Section 12, when you consider a bail application, especially in heinous crimes, in petty offenses or serious offenses, I think more or less boards have changed their mindset. They have started releasing the juveniles on bail. But there is a lot of mental resistance in case of heinous crimes. I'm not saying that everybody should be released on bail simply, even if he is involved in heinous crime. I am saying apply the provisions of Act, and where he is covered by the provisions of Act, the benefit of Act must go to child. The decision must definitely be in favor of child if the situation so exists. Now, another question which generally arises in bail matters is, can gravity of offense can be taken in consideration while denying the bail? Yes, please. I would like to seek your answers, because I know every stakeholder sitting in this room is much more experienced than me. You have experience of field, I have experience of academics. Yes, please. Anybody? Can gravity of offense be taken in consideration while deciding a bail application? No. So what do you understand by ends of justice? Now, let us take the Nirbhaya case. In Nirbhaya's case, the girl was brutally killed, raped and killed. And in fact, there was a public hue and cry, and in fact, it has resulted in amendment of Act itself. Now, if you have seen the television coverage of December 2012, you will find there were a lot of pressure on the government, police, and everybody, all stakeholders. There were a lot of pressure that one of the accused should not be granted bail. Now, the offense was very grave. He was denied bail. So, whether it was gravity of offense which resulted in denial of bail, you are right. The answer is that gravity of offense is not to be considered. Then how can in such cases you deny the bail? Absolutely. This is the absolute correct answer. There is no straitjacket formula. The grant of bail and decline of bail is totally dependent upon facts and circumstances of case. The only requirement is that three conditions must not exist. Now, gravity of offense can be one of the consideration to a limited extent. I'm saying to a limited extent when we discussing the third aspect whereupon bail can be declined. That is, person's release would defeat the ends of justice. Now here, what is ends of justice? Now brutal, if an offense has been committed in a brutal manner, and if such a person is released, what would be the impact on, general impact on the society? The general impact would be very negative, and it would result, everybody will think that justice has failed or there is no justice. That is why a very wide term, ends of justice, has been used in section 12. And I tell you, this provision existed even prior to Nirbhaya. It has not come in statute book after Nirbhaya. It is existing since prior to Nirbhaya. So the intention of legislature from day one was very clear that this act is a beneficial act for the upliftment of juvenile, a children, whether he is in conflict with law or whether he is in need or in need of care or protection. So it is a beneficial act. I'm repeating again and again because unless this fact is engraved in your minds, you will not be able to do justice to section 12 and section 15's mandate. There are other issues also connected with the bail aspect, whether bail can be cancelled or not. Yes, please. Yes, please. Can bail be cancelled? Cancellation of bail generally is not permissible. Even Supreme Court says that once bail is cancelled, it can only be cancelled in exceptional circumstances which have been illustrated through judicial pronouncements. Whereas Juvenile Justice Act again is an act which is beneficial in nature. So it is on the better footing than criminal procedure. So in this case, can it be cancelled? It cannot be cancelled. Now I'll give an example. You say it cannot be cancelled. A child has committed a rape. He is granted bail. Prior to commitment of bail, he was addicted to internet and he was watching lot of different type of activities on internet. After his release on bail, he start indulging in those activities, and there's a clear evidence that he's indulging in these activities, and there's a chance of he may repeat this crime. Now, this material is placed before you. Would you cancel the bail? You are right on first principles that once bail is granted, it should not be cancelled, especially when this is a beneficial act. However, again, the beneficial act further put a duty on the board and children court that welfare of child. The beneficial interest of child is the paramount. Bail can only be cancelled. It can be cancelled in exceptional circumstances. It cannot be cancelled in routine manner. It can be cancelled in exceptional circumstances. It is just like grant of death penalty in a 302 case. rarest of rare case concept is to be applied in case of cancellation of bail under section 12, which is to a juvenile who has been granted bail under section 12. Only when it is beneficial for his or her protection or safeguard, it is in his interest to cancel the bail, not otherwise. It's, I just given the example that he was addicted to internet, and he's indulging the same activities, and the material is brought before the court. Court can cancel the bail in such circumstances if the material is existing, and if court finds that by cancelling bail some reformative steps can be taken, then alone bail can be cancelled, not otherwise. So take it for granted that out of 100 cases, only 0.1% cases you can exercise this exceptional jurisdiction. This is not to be exercised in a casual or in a routine manner. Then why it is important to have preliminary assessment? Yes, please. For assessing the mental level of the juvenile, right? Basically, you are close to the answer. You are right. I'm refining it further. Basically, it is to find out whether the child has to be tried as an adult if he has committed a offense which is heinous in nature and he is between age of 16 to 18. So, first of all, we have to conclude in what cases preliminary assessment can be conducted. It can only be conducted where a juvenile is between 16 to 18 years of age, not otherwise. Number two condition is that he has committed a heinous offense fully described or defined under the provisions of section 2, subsection 33. So you have to be very careful that preliminary assessment under section 15 can only be held if these two first conditions are fulfilled. Unless these conditions are fulfilled, no preliminary assessment can be done. Now the next question would be how to assess it, and what are the factors which can be taken in consideration while assessing the preliminary assessment, while making the preliminary assessment. One, my learned friend has informed us to assess his mental capacity. Is there any other factor which needs to be taken in consideration while making preliminary assessment? Yes, please. Physical capacity also, you are right. Anything else? Mature understanding. Mature understanding, to my mind, would be covered by mental ability. And any other thing? Yes, please. The third is ability to understand the consequences of offense. This is also, though it is part of mental ability, but it has been specifically stated separately in the provisions of section 15 so that this important aspect is not missed out by the board. And the fourth thing which can be seen is the circumstances in which he allegedly committed the offense. Now these four conditions are to be seen. Mental ability, that is mental and physical capacity to commit such offense, ability to understand the consequences of offenses, and circumstances in which this offense was, the offense was committed. Now the next question would be, why it is important to have preliminary assessment, and what would be the effect if no preliminary assessment is made in a case where the juvenile is more than 16 years and has committed a heinous offense. There can be three situations. that one, there is delay in making preliminary assessment. What is the time period? Whether it is mandatory or it is directory in nature. Whether if no preliminary assessment is made, what will be the consequences? And in case no preliminary assessment is made and this fact is brought only in the notice of appellate court for the first time, no objection is raised by child before the, either before the board or before the children court. But before the appellate court for the first time, the ground is taken that no preliminary assessment has been made. What would be the effect? To know all this, we have to we have to first find out whether making a preliminary assessment is mandatory or not. Yes, what do you feel? It is mandatory or not? Why it is mandatory? What is the reason? Yes, this is one of the reasons that it is the best interest of the child. Because you see, the moment court concludes after preliminary assessment that a child is an adult, the entire course of inquiry against him changes. The nature of punishment changes. Earlier, he could have been sent to a special home only for 3 years. But if he is declared as declared as adult after preliminary assessment, then he would be tried as an adult and can be punished for a imprisonment which cannot be death sentence or life imprisonment without any chances of release. But other sentences, other period of sentences, 15 years, 10 years, 7 years, they can be given to that such like juvenile who has been considered to be adult. So the ambit changes, his rights changes. So it is mandatory. It cannot, there is no escape from making preliminary assessment in case of a child who has committed who has been found to have committed heinous offense and is between 16 to 18. The next would be, what is the time period in which preliminary assessment is to be made? 15 days? 3 months, yes. Section 14 gives the time period. It gives the time period. It says 3 months. Why 3 months? Why 3 months have been given in such like cases for preliminary assessment alone? Because it is not very simple thing. It is a very substantial right of a child. This substantial right cannot be done, it cannot be decided in haste. All type of material which would be against and for the benefit of child, they should be placed before the board before preliminary assessment report is made. So it is very important that no haste is done in this matter, and accordingly the legislature have thought it proper to give sufficient time to the board to make a preliminary assessment within 3 months. Now next question would be, if the preliminary assessment is not made by you in 3 months, what would be the consequences? Will it get vitiated? Yes, please. It will not. Why? You have failed in doing your duty. The mandate of act is 3 months, and you have taken 2 years to decide preliminary assessment. Yes, please. Shouldn't that child be released and the charges be taken back, charges be dropped against that child? The answer is, we have to find out the nature of this preliminary assessment, the time period, whether the time period is mandatory in nature or directory in nature. There are different judgments of honorable courts wherein it has been held that 3 months period is only a directory thing. It is not mandatory. The next question, I will share the relevant judgments with you. The next question would be, it is okay, it is not mandatory. we have missed the deadline of 3 months. Now, what would be the consequences? Yes, please. What would be the consequences? Let us say there is a delay of 1 year. Yes, please. Any idea? Yes, please. Please give the mic. Yes, please.
तो बच्चे का जो मेंटल कंडीशन है, जो मेंटल स्टेट है उसकी, वो मैच्योर हो चुकी होगी उसके बाद. अगर 3 मंथ में नहीं की जाएगी तो वो मैच्योर हो चुका होगा. अगर उस टाइम उसकी असेसमेंट की जाएगी तो बच्चे की जो मेंटल एबिलिटी उस टाइम थी वो सही तरीके से वो समझ में नहीं आएगी सर.
तो इसका मतलब कि हम छोड़ दें इसको?
नहीं, छोड़ने का मतलब नहीं.
फिर इसका क्या इलाज क्या है हमारे पास?
बच्चा और मैच्योर हो जाएगा ना उस वक्त तक.
नहीं, बच्चा नहीं, इसका इलाज क्या है? 11 महीने, अगर 11 महीने लग गए. अब मैं आपको एग्जांपल देता हूँ. ये जरूरी नहीं है कि भी एवरी टाइम द बोर्ड इज एट फॉल्ट. समटाइम्स सर्कमस्टांसेस आर एट फॉल्ट. आई विल जस्ट गिव एग्जांपल. द प्रिंसिपल जज is not appointed in a district. Member is not appointed in a district for some reasons. Only one member is working in a particular district. Now he cannot make preliminary assessment. What can be done? The board is not at fault. Here in this case, board is not at the fault. Fault is of circumstances. What should be done? What should be criteria to accept or reject such like preliminary assessments?
No idea.
Okay. Yes, one is there has to be reasons for such delays. Delays must be explained. I have given the example. If the quorum is not complete, if the judicial officer and members are not there, if the board is non-functional, you can't find fault with the board. It is fault of the circumstances. The delay is explained. Now, in case delays on the part of board, then board is responsible. You see, the liability of board is there in case the board is not, though the liability is not criminal liability, it is administrative, or you can say departmental liability. If a judicial officer is found at fault, of course he can be proceeded, disciplinary action can be taken against such judicial officers who have been negligent. A different manner of making people accountable. But accountability will have to be there. Therefore, in such cases where there is a delay, the basic principle which is to be seen is twofold. One is whether there is justified reasoning for delay in assessment, and number two, there is any prejudice to the child or not. The principle of prejudice is very well established principle in criminal law also. There are two things in criminal law: irregularity and illegality. In case of illegality, the basis goes where there is an illegality, in that case the order is void ab initio. However, in case of irregularity, the order is not vitiated. It can be vitiate, but it is by per se it is not vitiated, and it is to be seen whether the accused or the child. In case of criminal law, it is accused. In case of Juvenile Justice Act, it is child. Whether any prejudice has been caused to him. If the prejudice is caused, then the assessment can be set aside and reassessment can be ordered to be done. Generally, there are a number of cases. I'll just give example. You will get the answer. This I will not now. It will be premature to answer the illustrations to the answer to the illustrations which I had raised in the first, in the initial, at the start of this session. The answer would to one of the queries or illustration lies in this, what we have just now discussed. Now, whether the next question would be whether preliminary assessment is a trial. What is it? Assessment, yes. It is just like another inquiry. It is not a trial. This another question which would arise, whether the child has a right to participate in this preliminary assessment. Yes, please. He has a right. It is an assessment to be done by you. Where is the right of child? Don't you feel that there is no requirement to to uh, to join the child in this assessment? Yes, please. You are right. Otherwise, also Juvenile Justice Act, in fact, mandates that each child has complete right to have a fair trial, to participate in proceedings before the board, as well as children court. And since this is an inquiry, it is a proceeding before the board or children court, therefore, the child has all the rights. And if this right is denied, it may cause prejudice to him and make the preliminary assessment liable to be set aside. Now, kindly note, I am repeating time and again the principle of prejudice. Because if the prejudice is shown to be caused, then no preliminary assessment can be sustained. You have to ensure while making preliminary assessment that no prejudice is caused to the rights of the child. This is one of the basic thread which you have to keep in your hands while deciding preliminary assessment. Yes. Now let us come back to 4 illustrations which we had given. Yes, please. Let us talk about first illustration. Child married at the age of 14, having a very abusive marriage, was being given beatings by her husband on daily basis. On the day of incident, she was again given beatings. She took a axe, gave a single blow, the man died, and preliminary assessment is to be made in such case. Now what do you do? Whether you will hold her to be adult or you will hold her still to be a juvenile, not capable of being tried as an adult. Yes, please. Juvenile. Why? Basically, law is nothing. Law is reasoning. What are the reasonings? This is one reason. Any other reason?
Moreover, the age when she was married, she was minor, and by the time the final this thing happened, she grew up. But the link between the time was the one reason for it.
Anybody else? पीछे दीजिए. Anybody from backside?
Sir, to my mind, after conducting preliminary assessment, we have to see whether at the time of commission of the offence, her age she was below 18, number one. Then we have to see whether she was having a bent of adult mind, she was able to understand the nature of crime or the consequences of the offence, and whether she was aware of the circumstances after the commission of the offence, what would be the consequences of the offence she has committed. In that case, keeping in mind all these circumstances and preliminary assessment, we will treat her juvenile, or we will declare like she is to be treated as a child. To be treated as an adult.
adult. She cannot be treated as adult, or she should be.
So to my mind, because when she committed the crime, she was about 17-year-old. So she cannot be, and we have to go through the preliminary assessment, and we have to see whether she was aware of the nature of the offense or the consequences of the offense. Only then we can make up our mind for that, whether she should be treated as a juvenile or she should be treated as an adult.
Okay. Let us pass on the mic to that side.
I would not send it. So I would treat her as a juvenile because it may have been an act of self-defense also. So these circumstances have to be kept in mind besides the heinous offense, the nature of offense.
Thank you, ma'am. Every one of you is right. Let me conclude it. You see, there is no straight jacket formula to conclude whether a person is not dependent on the facts, simple one or two facts that we can conclude that a child has to be treated as an adult or not. It is the cumulative effect of all the four conditions stated in section 15 which have to be taken in consideration. As ma'am has said, that it will depend on facts and circumstances of each case. Yes, fact and circumstances, cumulative taking all the four conditions mentioned in section 15, you can come to the conclusion. Yes, ma'am, you were also right. When circumstances to be seen, this is one of the circumstance, this is one of the, you can say, condition stated in the section 15. So circumstances in which the offense was made. Then you were also right when you said that what were the consequences of offense, whether she was fully aware of the consequences. Now if we in fact analyze the case, the facts of the case, keeping in these four conditions, now mental state, physical state, the ability to understand the consequences and circumstances in which she has committed the offense. Now all four would be attracted. The fact is, she was 14 years old, she was married in an abusive matrimonial life. She has been getting beatings from at the hands of her husband for the last 3 years. Now, you can imagine the mental condition of such a child. You have to take in consideration the mental condition of such a child. Then, physical capacity is not, she had given a single blow that was sufficient to kill the man. So she had the physical ability. There is no problem. Then whether she understood the consequences of offenses, the nature of fact that she had given only a single blow, and that too after getting the beatings from her husband, who has been beating for the last 3 years. Now, she was not aware. This only goes to show her mindset that of consequences, she was not fully aware about the consequences. You can take a presumption that she was not fully aware of the consequences. And similarly, she was not within, we have to take the circumstances in which this offense has been made. Circumstance was that she was left with no choice because she was regularly getting beatings, and she was in an abusive marriage. She was at the very tender age, she was put to these conditions, and she was only 17 years. So these circumstances, when taken collectively, all four things, then the conclusion would be that she cannot be treated as an adult. Her mindset was still of a child. She cannot be tried by children court as an adult. Now coming to the second illustration, the Gurgaon case. Yes, please. The child was given IQ test report or other test reports which was conducted by a psychologist just 35 minutes before the arguments in the court, whether it is sufficient compliance, whether any prejudice is caused. Yes, please. How many of you are interested in wrestling or boxing? Yes, please. Anybody interested in boxing or wrestling? Or ever seen a wrestling or a boxing match? I think even if we are not interested, we must have seen wrestling and boxing match. There is a concept of weight category in both the sports. What is weight category? Yes, please. Weight category is that similar persons can fight with similar person. Disproportionate, there cannot be a fight between two different people. There cannot be a fight between me and Dara Singh because we have no match. So this concept also would to be seen when making the preliminary assessment. The concept is whether fair chance has been given, and when the fair chance, we talk about fair chance, we have to see that the same circumstances, we have to see the circumstances in which fair chance is to be given. Now, can an expert report be countered by an advocate or by a child or his or her parents within 35 minutes? The report was running 35 pages. The answer is no. There was effective denial of a chance to contradict that report. That means it has caused prejudice to the child, and accordingly the conclusion would be, yes, what would be the conclusion? Yes, the preliminary, in this case, preliminary assessment has already taken place. It was held that preliminary assessment is defective. It is not, it cannot be accepted. Now coming to the third case, wherein the boy had called the girl, raped her, killed her. He knew the circumstances. He narrated how the crime was committed. Everything he disclosed to the counselor. Now, in such cases, whether preliminary assessment report would be justified or not? Yes, please. It would be justified or not? Justified. Why it would be justified? Proper hearing was given. His mental capacity was seen from the fact that he is narrating the occurrence in a very cold-blooded and a very calm manner. He knew the consequences. He was a young boy of 17 years. This additional fact, all these facts taken together, again, the idea is we have to find out whether the juvenile had mental, physical capacity. We have to find out in what circumstances he has committed the offense, and also whether he had ability to understand the consequences of the offense. Why I am repeating all these repeatedly, why I am making repetition? There is only one reason, because there is nothing else in this section. These are only 4 things which we have to apply, and when we have to apply very carefully, because it will depend, it will make or break the future of a child, which is dependent on your decision, on your preliminary assessment. So we have to be very careful that we'll be wasting or utilizing a child by our decision by taking care of these 4 conditions. Now, there is another 4th illustration which I have given. I've just skipped. It has skipped from my mind. Can you repeat that? What was the illustration? Yes, Bombay case. What would be the fate in that case? A child from an affluent family was visited by a neighbor, another child, younger than him. She was irritating that child. Out of irritation, the child in conflict with law had pushed her, resulting into her death. He got scared. He concealed her dead body. After concealing her dead body, he came to know after concealing her dead body, he heard someone saying that there is no ransom call. He made a ransom call. He also involved another juvenile along with him in this occurrence subsequently. Now, what would be the conclusion which should be drawn by the board, whether he should be treated as an adult or not? Another fact which I will like to add before you respond to this query is that while he was interviewed by counselor, he was remorseful. He was, in fact, he knew that what he has done is wrong. He was studying. He passed his examinations. He was in 11th class, he passed his examinations. And he was doing good in academics. Now, what would be your decision? If this case comes to you, how would you decide this case? Yes, please. Anybody from behind? He should be treated as juvenile, not a child, not an adult. Okay. Reasons. He was not aware of the consequences. Yes, he throughout his interviews maintained that it was an accident. He had narrated the entire incident. Now here the circumstances in which he has committed the offense has to be seen. Now we have to see that it is an accident. In such like cases, of course, we can come to a conclusion that the child should be treated as juvenile and not as an adult. Now,
Sir, I have a question.
yes, please.
Sir, like you stated, there was a delay in preliminary assessment which can prolong till 2 years, okay? And
No, I have given a.
It was an example.
It cannot.
okay, if there
Please
was
don't
some-
take it that you can prolong the preliminary assessment. You are supposed to do it within 3 months.
3 months.
It cannot be prolonged.
Yes, but
I am taking a hypothetical question that if it had,
yes.
then in such a question.
Then will the preliminary assessment will be justified if it is done after that stage? Because during that period, the mental growth of the child would have.
No, it
increased.
can be. It is justified. You see, if the reasons are there of justifying the delay, and the preliminary assessment has been done in the manner as prescribed under section 15, then of course it will not be quashed merely because there is a delay on the part. Delay in itself is not sufficient to quash it. Kindly understand, delay itself is not sufficient to quash a preliminary assessment. It may be different issue that a preliminary assessment is quashed because it is not as per section 15. That is a different aspect. But delay in itself will not vitiate a preliminary assessment. Delay, why? There is a reason for it. Section 14 prescribes 3 months' time.
Yes.
Now, the courts have considered this provision, whether it is directory or whether it is mandatory. Court, after considering this provision, have concluded that it is directory in nature. It is not mandatory in nature. Period, you see, there are two aspects. Preliminary assessment is mandatory. Conducting it within 3 months is directory. These are two different, kindly understand these two different things. These are two different things. These are not one and same thing. It is irregularity, it is not illegality. It can be cured, yes. And again, I tell you, even if in case there is a defect in preliminary assessment, courts would definitely go into the question whether any prejudice is caused. Let us say a preliminary assessment is done and it is found that the child is the child has to be treated, child in conflict has to be treated as a juvenile. Now, what prejudice is caused? Nothing. It is rather in his favor. So it will not go back to the assessment stage. There is no prejudice caused. He will still be tried by the board. So the prejudice has to be seen. Unless there is a prejudice, the order of this preliminary assessment would not be set aside. Now, another question which is very important, whether the report of psychologist has to be mandatorily involved, taken. Now, before that, I missed one important aspect of section 15. One of the mandate of section 15 is that board, while making preliminary assessment, may take help of psychologist, physiologist, or any expert in in working of child. Now, the section 15 permits the board to take help of a expert. The question would be whether it is mandatory. If you fail to take, why it is not? How would you come to the conclusion that there is no mental ability? No, there are number of judgments wherein Honorable Supreme Court, Honorable High Courts have interpreted that may word can be substituted by shall and shall word can be substituted by may. While interpreting a particular act, it is the spirit behind that particular act which is to be seen. And accordingly, may and shall are replaceable words. This interpretation of Supreme Court is available in number of cases. May has to be read as shall.
Can these words be replaced of our own?
Pardon?
May and shall words can be replaced of our own?
No, we cannot. But
Yes.
but higher courts, while interpreting a particular provision, keeping in view the purpose of the act, purpose of the provision, can interpret a may word to be shall and shall word to be may. There are a number of instances of such like interpretation by high courts and Supreme Court. The question is not may. Question is, it is not that merely because the word used is may, you have a discretion not to involve an expert in the process of preliminary assessment. It is the requirement of preliminary assessment whether an expert is required. It is your decision. That decision has to be based upon reasoning. It is not dependent upon word may. It is dependent upon the requirement of a particular case. So, in a particular case, I'll just give example why psychologists are very important. Because it is a structured science. It is not something which is not structured or which is not based upon some principles. When it is based upon some structured science, it is just like medical science. It is in fact a medical science. Then we should use that tool with us, because there is a IQ test. Because next session would be taken by an expert. She'll be able to tell better than me. We all have IQ. Many of us go through the IQ test. Now, what does it denote? What IQ denotes? There is a score of 70. There is a score of 70 to 90, 90 to 110, 110 to 125, 145. Einstein had IQ score of, I think, 125 or 145, I'm not very sure, but it was something like in that range. Pardon? 160? Okay, 160. So, what does these IQ scores donate? In fact, they tell us that what is the mental ability. You see, the mind develops, primary development of mind takes place when a child is up to 5 years. The primary development takes place by 5 years. The IQ more or less, it changes a bit, but more or less development of mind is considered to have been taken place in first 5 years. So it also helps you to understand that if a IQ score is less than 70, then you will be able to better understand circumstances and whether the child was able to understand the consequences. Both things can be related to mental ability of that child. So my personal opinion would be that merely because word may has been used in the section 15, the opinion of experts should not be taken lightly. It should, depending upon facts and circumstances of each case, it can be taken, it should be taken. There is no harm in it. The next question would be whether board is bound by this opinion. The answer is no, because it is a decision to be taken by the board, not by the expert. If the decision is to be taken by the expert alone, then there was no need to enact section 15. Section 15 would simply be worded that an expert opinion be taken, and on the basis of that expert opinion, the child would be declared as an adult or a juvenile. So that is not the mandate of section 15. Section 15 only gives you a additional tool in your hand in the shape of expert report. It is ultimately all four factors are to be seen by you, and after considering those factors, you have to decide whether the expert report can be partially applied, fully applied, or not to be taken in, not to be applied. So it is all up to you.
सर इससे थोड़ा सा हटके एक सवाल पूछ सकता हूँ क्या?
बिल्कुल बिल्कुल जी, हाँ जी बिल्कुल.
Sir, whether the board is competent enough to record confession of a juvenile?
आप बताइए, आप you are most, you all people are most experts, most eligible persons to answer this query, because you see, it is you who on daily basis come across these situations. Yes, please.
Sir, to
The
my
Principal
mind,
Juvenile Justice Board, they may answer it. Yes, there are, I think 44 of them are there.
yes,
It can be.
sir, whether it is not against the concept of JJ Act?
The reasons, kindly tell the reasons. He has raised a very valid query.
Sir, see Rule 8, Subclause 3, Subclause 4 and 5, where it is mentioned that police may not compel the juvenile to record confession.
May not compel.
Yes, yes.
Now, if
फिर
somebody
वही
comes
may और shall
voluntarily,
वाली बात आ जाएगी,
if
sir.
somebody comes voluntarily,
Yes, sir.
if you see, human beings react differently in different circumstances, in different manner. No human is similar. There are people who accept, who confess what they have done. There are people who refuse to accept, even after Supreme Court judgment in their is given against them, they'll still say that they are innocent, even though they knew that they have committed the offense. So people act differently, react. Can you stop anybody to voluntarily make a confession? If somebody comes voluntarily,
मुझे सर ये लगता है कहीं ना कहीं हम अपने काम को कट शॉर्ट करने के लिए कन्फेशन रिकॉर्ड करके और इंक्वायरी को खत्म कर देते हैं.
no, that is not permissible. You are right. If we are doing that, that is not permissible. This is not permissible. Now, another question which I'll raise before concluding.
Sir, I would like to add here
Yeah.
something.
Now, I'll take a minute.
Yes, sir.
There is another aspect which I like to discuss, that is whether default bail will be applicable. I left because we were discussing preliminary assessment. We left this particular aspect. Under section 167(2), whether default bail would be applicable. What is default bail? I hope you are all aware of default bail. If the challan is not filed within 60 or 90 days, as the case may be, depending upon the nature of offense, then the accused gets a right, vested right to get bail. If the challan is not filed within 60 days for lesser offenses, and for serious offenses, I'm talking about general law. I'm not talking about Juvenile Justice Act. So that, whether that, because 167(2) has been enacted for general law, whether that principle is applicable in case of Juvenile Justice Act, the answer is yes. There is a judgment, I refer to a case of Gurgaon, that is judgment of Honorable High Court, Bholu versus State of Haryana. And in that case, this issue was also taken in consideration, and it was held that yes, juvenile would be entitled to default bail in case challan is not filed within 60 days. Why 60 days? Because in case of juvenile, no juvenile can be sentenced to death or imprisonment without there being any chances of release. Therefore, for life imprisonment without release and death sentence, it is 90 days in general law. But in case of Juvenile Justice Act, it is 60 days. So 167(2) default bail would be applicable. That principle would be applicable. Yes, ma'am, please, sorry.
It's okay, sir. I stated in the beginning of the session that there are 16 principles provided. So to my mind, one of the principle is also that he should not be allowed any act which is against him, because he is not of that mental age to understand the things. Only the councils do, and the board as the foster parent has to look into these things. So the circumstances have to be seen, and when to use it, if he really confesses or not, that has to be seen.
Last aspect which I like to share with you is whether in case preliminary assessment has not been made and it is raised for the first time at the appellate stage, can it be raised at the appellate stage? Yes, please. Can it be raised at the stage of appeal? Before the board, no challenge was done as regards to preliminary assessment. No preliminary assessment was undertaken. And board recommended the case to children court, and children court tried the accused as an adult, sentenced him. Appeal is filed by the child. Now, can he take a ground that preliminary assessment was not undertaken by the board or children board? Can he take this ground while filing the appeal? He can. Now, what would be the result? Whether the appeal will be accepted, he'll be left scot-free, or something else can be done. Can a court, appellate court, remand a case to the board whether it is within its power under section 386 of CRPC? Yes, please. Sir, please don't get influenced by word may and shall. I am again requesting you all, please don't go by word may and shall. You have to take facts and circumstances, because you see, criminal law is nothing, but it is facts and circumstances of each case, because each fact makes a case different from other case. So you can't compare, there is no straight jacket formula when you are appreciating a criminal matter.
Sir, my answer is the appeal has to be considered by the Children Court under section 101 and Children
No, it is the order of Children Court.
Jesus.
It is the order of Children Court. You see, board has not made preliminary assessment.
Yes, sir.
Children Court has also failed to make the assessment, though it is duty bound under section 19 of the
Sir,
Act.
then he has a right to invoke the court before the High Court under section 102. revision में जाएंगे और फिर High Court उसमें order करेगा, sir.
Okay. I'll just refine it. Let us say no preliminary assessment was done by board. The matter goes, he was declared as an adult. Matter goes before the Children Court. Children Court, however, treats him as a child and proceed the case as a summons case and sentence him accordingly to go in a special home for 3 years. He files an appeal, the accused. He takes an query, he takes a argument that since preliminary assessment was not done either by board or by Children Court, therefore the order itself is vitiated. What will happen? This is first situation. Second situation is same facts. The only thing is Children Court has treated that child as an adult and has sentenced him for 7 years. Then what would be the consequences in the appeal? The answer, I'll give the answer because we are running short of time, I suppose. So I'll hurriedly give the answer. The answer is that again the principle of prejudice has to be seen. In first case, there is no prejudice because Children Court has treated him as a child. Preliminary assessment, whether it was there or not there, it has not caused any prejudice to him, and therefore he would be, there will be no illegality in the orders of Children Court. However, in second case, in absence of preliminary assessment, the case would have to be remanded because section 386 CRPC permits appellate court to remand a case in a fit case in the facts and circumstances of the case. So in second case, where no assessment has been made either by board or by Children Court and default, the ground is raised for the first time before the appellate court, the appellate court can conclude that prejudice has been caused and therefore remanded back to the, now where would it remand? Board or Children Court?
It's the option to the
No, because there is a law is very clear.
Sir,
Okay, I'll put
Children Court को जाएगा, sir.
I'll put this question again in different way. Can if a suppose, let us say, a board concludes that a child has to be tried as an adult, sends the case to Children Court, but Children Court makes its assessment fresh assessment and concludes, no, child has to be treated as juvenile, he cannot be treated as adult, then whether it will remand back to the board or it will try the case itself.
Sir, in that situation, the Children Court work like a board and hold inquiry in itself.
So the answer, you have given the answer. The answer is that once the case has gone to Children Court from board, it will not be remanded back to the board. If the appellate authority would remand the case, it would remand to the Children Court, and Children Court, after preliminary assessment, if it concludes that it is a juvenile, then treated as a summons case, same procedure as summons case would be tried, and otherwise it will be tried separately as an adult. So thank you very much. The time was very short, 1 hour was not sufficient. I must have skipped a lot of material, but it is quite enriching. Even I have gained a lot of things. I was not very much clear about the provisions of, I took help of my officer, Mansi, who is sitting amongst you, and she has given a lot of material to me. I have prepared from that material. Thank you, Mansi. Thank you all.